Welcome to this webinar organized by ELSA and FRAND Council about the IP aspects to consider when entering the Internet of Things. My name is Claudia Tapia. I'm the president of FRAND Council and I will be your host today. As you may know, FRAND Council is a non-for-profit research organization focused on the link between IP and innovation. We identify the most relevant topics and offer empirical research by working closely with a wide variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find a range of free materials, studies, guidelines, summaries of relevant papers, and recordings of webinars like the one today. Moreover, we produce easy-to-digest content, specially tailored for non-IP experts, SMEs, and startups. This is free of charge too. And some examples are interactive graphics and interviews to inspire them. And with this, we aim to assist innovative startups and SMEs to learn how to grow their businesses using IP. Today, we're going to talk about a topic which, independently on the sector you choose for the next steps of your professional career, you're probably going to deal with it. As you know, more and more things are getting connected thanks to the Internet of Things. And since the last few years, we are seeing different sectors incorporating their technologies to enhance their products and services. We see that in health, manufacturing, you probably have heard about this Industry 4.0, and logistics, in transportation, in energies, in aviation, and much more. We enjoy or are about to enjoy smart cities, smart health solutions, intelligent transportation systems, and the benefits from the economic point of view are huge. It is expected that the Internet of Things, or IoT, incorporated products and services generate between 5.5 to 12.6 trillion US dollars to the global economy by 2030. Automotive alone is expected to earn between 450 and 750 billion US dollars every year only with the data connectivity service. So what is important for what we are talking today? It's because IoT relies heavily on wireless connectivity, such as those from 4G and 5G standards. And since these groundbreaking technologies are the result of massive R&D investments, they are often protected by patents. The good news is that these patents are typically available on fair, reasonable, and non-discriminatory terms and conditions, known as FRAND terms. And FRAND terms are usually determined in bilateral licensing negotiations, good faith licensing negotiations between the owners of standardized technology, which is patented, which I'm talking about owners of standard essential patents, or SEP holders, and those using this standardized technology, SEP users. And today, we will discuss about how to behave as a willing licensee and as a willing licensor in FRAND licensing negotiations. And we will have a special focus on Europe. In particular, we will see a lot of what is happening in Germany and in UK, where we have the majority of the cases. And without further delay, please allow me to introduce you our great speakers. We have Richard Berry, who is a partner in Bird IP Practice and Tech and Communication Sector Group. He specialized in multi-jurisdictional electronics patent litigation with a particular focus on mobile telecommunications, patent litigation, and arbitration work. And then we have also Cordera Schumacher, who is a partner of the German boutique IP firm Arnold Roos. She specializes in patent litigation, and she has been lead counsel in the key FRAND cases in the last years. I'm truly delighted to have you here, you both. And after the presentation, we will start with the Q&A. But for now, Cordula, would you please explain us what is this FRAND licensing negotiation is about? How should we behave if we own SEPs or use SEPs? And what happens if we are not behaving in good faith?
Yes, thank you, Claudia, also for the kind introduction. And I'm very pleased to be here with you on this highly interesting topic. And maybe let me start with just explaining a bit the systematic that has been laid out by the European Court of Justice in the decision Huawei versus ZTE. That decision is already a couple of years old, but it's still the fundamental basis of FRAND and SEP cases in Europe. And I would like to explain to you a bit the mechanism that the CJEU has had in mind, and then maybe we can turn on to how it's being lived in practice in the European countries. So the CJEU on both hands, first of all, considers that IP rights are essential rights and that the proprietor of an IP right is entitled to injunctive relief. But on the other hand, it also says that someone who's implementing a standard has a reasonable belief that he will get access to a license. And the CJEU then says, well, in order to get to a FRAND license, in order also for the patent owner to be able to enforce his rights and get injunctive relief, a couple of steps should be performed. The CJEU is thinking of an ideal set, an ideal course of negotiations in order to check whether both parties are behaving in good faith. So there are some obligations for the patent owner how to behave, and there are some obligations for the implementer how to behave. And typically, the CJEU envisages the following process, that typically it would start with the step one with the notification, so that the SEP owner notifies the implementer about the patents he is infringing. Because, and that's the argument of the CJEU, an implementer might not be aware of all of the patents he is using just because of the sheer amount of patents. And of course, the CJEU also might have in mind that some implementers might be very sophisticated and know it all, but there might also be a lot of implementers who have no clue about that, maybe even smaller companies in the sector of the IoT you mentioned beforehand, Claudia. So that's why the patentee should notify the implementer. And then once the implementer has been notified, this implementer is obliged to reply and to reply promptly without any due delay to the patent holder and tell him, yes, I am willing to take a license. I'm willing to take a FRAND license. If he does not reply and thereby shows that he's not interested in taking a license, then he also loses his right to a FRAND defense and an injunction may be granted. If he does express his willingness and an honest sign of willingness, and it stops there and no further steps are being taken, then there might be no injunctive relief for the patent owner. So let's just assume that there is the sign of willingness, then the patentee shall react to that by providing a FRAND license offer. And the CJEU thinks that in principle, it should be the patentee who provides the first offer, because it's the patentee who has been licensing out his patent or his portfolio a couple of times. So it's the one who knows what are FRAND terms, what are the terms that are being accepted in the market, what are non-discriminatory terms. So he has more information than the implementer, and that's why it's the patentee who should give the first offer. And if this offer is on FRAND terms, all is good for the patentee. But if that offer is not FRAND and is rather considered to be abusive, injunctive relief might be denied. If the offer is FRAND, then again, the ball is in the field of the implementer, and the implementer has to react to such a FRAND offer, either, of course, by accepting it and thereby terminating the dispute with the license, or by making himself a counteroffer, a FRAND counteroffer. If he does not react with a counteroffer, then again, an injunction might be granted. If he does react with a counteroffer on FRAND terms, the question is then, does the patentee accept it? And if he accepts it, then again, the dispute is over and there's a license in place. If he does not accept it, the implementer then has to provide a security, for example, by a bank guarantee, in order to show that he is actually living up to his offer and he is honest about it. The question whether then injunction will be granted if security has been provided is under dispute in Europe, and the CJEU is not clear about that. Some argue that yes, an injunction should be granted, and others are against that. But that remains to be seen how the courts will deal with that. And maybe I stop here, Claudia.
Thank you, Cordula. It's been actually a great way to show all these steps, but when I'm looking at them, how do you see them, or how does the court sees it? Is it a kind of rigid or flexible way? In other words, do they have to follow the concrete order, like step 1 and then step 2, or is it rather a framework that indicates what would be a good faith licensing negotiation? Maybe Cordula, would you like to start?
Yes, very, very happy to. So initially, and also by reading the CJEU judgment, you might think, yes, it is a step-by-step, because the court says firstly, and then secondly, and then after that, and prior to, and so on. So it's a chronological way. But on the other hand, the CJEU is talking about, is always referring to the individual circumstances in every case. And to a general principle of good faith. And so there has been a bit of a development in the German courts, at least. In the beginning, there have been a couple of decisions which applied a very strict step-by-step mechanism. And we've seen decisions that either a party has won or lost proceedings just because they did not comply with a certain step within a certain time frame. Sometimes it was a question of days. And not so much looking at the content, but rather looking formalistically at did they tick the box or not. That has changed since the German Court of Justice has given its decision in the Ziswell-Haier case. That's about 2 years ago. And there, the Court of Justice in Germany argued FRAND is a general principle of good faith and of behaving as parties wanting to conclude a license agreement would behave. And it's not about ticking boxes and not a formalistic approach, because that's not happening in real life. So now we have a much more flexible approach. And in the end, the key question is, who's the good guy, so to say? And that's the one who's winning the case. And you need to make sure that either side, and especially the implementer, has to make sure that he's willing to take a license, and that he gives at least the impression that he is doing everything he can in order to get a license as soon as possible.
Thank you. Makes absolutely sense. What about UK, Netherlands? Richard, from UK perspective, what can you tell us?
Yes, so across Europe, different courts obviously take slightly different views. The Huawei and ZTE case is relevant in the UK, even after Brexit. It is part of our law. But the English court reviews it as more like guidelines. And to a certain extent, it matters much less in the UK than it does in other countries. And the reason for that is that the English court isn't trying to make a decision purely on whether to grant an injunction or whether to refuse an injunction when somebody's been found to infringe a patent. What the English court sets out to do is work out what would be a fair royalty rate for this portfolio of patents. It will then offer that to the person who's been found to infringe and say, if you take a license at this rate, all is fine. If you don't take a license at this rate, then there will be an injunction. And because it's trying to get to that different position, it's less concerned about who has done what on the route to get there, because ultimately the English court is going to go there itself. So it pays less attention to whether the patent owner has made a fair offer at any particular point. It pays less attention to whether the implementer has made a fair offer at any particular point. And ultimately, it's diving into the final question of what is a fair rate, and let's offer that to the implementer. So yes, for us, they're much more like guidelines.
Thank you, Richard. Cordula, when you were making the presentation, you were talking about what happens after the infringement is notified, and how, I think the word you used was promptly, the reaction of the willing licensee. Could you maybe elaborate, what is it considered to be promptly?
Yes, well, promptly very much depends on the circumstances. Another technical term would be without undue delay, and it will in the end depend on the implementer, on the patentee, on the amount of information that has been exchanged. There is not a specific deadline. The case law has shown that waiting for a couple of months is certainly too long. So I would say promptly would be a matter of weeks, maybe quicker if it is an easy case, if it's just one standard essential patent, if the implementer is very sophisticated, and if the patentee has provided lots of information, then probably the time frame is shorter. If it is a very large portfolio, the implementer has never ever been involved in SEP licensing, and there's only very limited information available, then the time frame might be a bit longer. However, we always need to keep in mind that at this stage of indicating willingness, the implementer does not yet have to come up with a specific counteroffer, does not have to have evaluated everything, does not have to have analyzed every single patent, whether he's infringing it. It's just about a question of a feedback that, yes, I'm interested, yes, I'm willing. If I'm willing to take a FRAND license, I want to legalize the distribution of my products, because you always have to keep in mind at that stage, assuming there is a patent infringement, the implementer is distributing patent infringing devices. So the implementer should try to stop this status as quickly as possible. So in the end, it will depend, but I would say usually it will be a question of a couple of weeks. And I may add, because of the more flexible framework nowadays, even if it has taken a couple of months in the first time, previously the implementer would have been kind of kicked out and lost the proceedings, no matter what he did afterwards. Nowadays, I would say if he kind of makes up for it and has taken a bit too long in the beginning, but then kind of is very engaged and really shows that he's changed his mind and has become the good guy, he might make up for that.
Interesting. Richard, what do you think? A couple of weeks, months?
So in the UK, again, the restrictions are, the obligations on the implementer are somewhat lower. The implementer, so long as, once he's sued for patent infringement, he has to react very quickly to that, and he has to say, I am raising a FRAND defense, I want a FRAND license. And if he's done that, then the process will go through, we'll get to a decision about whether the patent is valid and infringed. And by that point, he has to have said to the English court, not only do I want a FRAND license, but I'm prepared to take a license on the terms that you, the English court, set. And if he hasn't said that, then he will get an injunction against him in the UK. The injunction will still be the FRAND injunction. In other words, he can still buy his way out of it by paying fair royalties later on. But there's a bit more of a process to find out what those fair royalties are. So there's a period of time in which he's utterly off the market. But the initial process of when the patent owner approaches the implementer, if the implementer completely ignores that, then the English court may penalise him in costs at the end of it. The English court may order the implementer to pay more in the way of attorney's fees. But otherwise, that doesn't preclude him from getting a FRAND license and raising the FRAND defence later on.
Maybe that is also the key difference in the approach we're seeing in the UK and Germany. And Richard, correct me if you see that differently. So while in the UK, the likely outcome will eventually be a determination of a FRAND license, which the parties can accept or not accept. And if the implementer doesn't accept it, he has to leave the market. But there will be terms coming out of that. While in Germany, we've seen many cases where the courts didn't even get into any FRAND assessment because the implementers have been unwilling. And the logic is that someone who's not engaging in a FRAND process is not entitled to a FRAND defense, because the German courts argue FRAND is something that shouldn't be really decided by a court, but it should be something that is being developed between parties, and that's being developed in honest negotiations. And only if you have parties negotiating, eventually you will get to a FRAND outcome. And the courts shouldn't decide too early. But if someone is not engaging, how do you want to come to a result? So kind of it takes two to tango, so to say. And if one party is not playing along, he's losing his rights. And that's why in Germany, we've seen many decisions where the implementer has been declared unwilling, lost his right to a FRAND defense, and therefore has been injuncted without ever getting to the question of what is a FRAND license rate.
I see Richard nodding, which I interpret as yes.
For the good or for the bad. So each approach has advantages if we're advising clients.
That's true. And the English court also has this lever of being able to award costs as a penalty for what it sees as bad behaviour. And I am sure that there will be situations where an English court does say there's a complete lack of engagement on this side by the defendant, and yes, I will go ahead and award an injunction. Classically, if they don't even reply to the claim form, then you would go to a default judgment. But it's just harder to lose your right to claim a FRAND license in the English court than it is in the German court, just because of the English court is trying to get to a number rather than trying to get to a yes/no decision on an injunction.
Makes sense. What about if the parties are already in litigation? Can they still make offers and counter offers? Cordula, would you like to start?
Yeah. So in principle, at least the offer should be done before the proceedings, because that's also what the CJU explicitly says. It says prior to initiating infringement proceedings, the patentee should make a FRAND offer. So that's literal wording of the case. And that's actually something that we would always recommend our clients to do before launching proceedings. However, because of the more flexible framework, I wouldn't exclude you could win a case even if you made the FRAND offer only after starting the proceedings. And likewise for the patentee, for the implementer. Ideally, you should have done that before proceedings start. You should have done your counter offer. But there might be situations where you can make a counter offer afterwards and still be heard. So the legal rule is that there's no preclusion under FRAND law. What applies in the end is the procedural law. When can you submit new facts to the court? And here it might also depend a bit on the circumstances. If there's an offer already in place, and then I don't know, 6 weeks before the oral hearing, you just change one clause, just one minor thing, that would probably not be delayed, because it's easy for the other side to react to that. If 6 weeks before the oral hearing, you present for the first time a full license offer, that might be delayed.
Richard, what about your case?
Yeah, so English courts expect people to keep negotiating during the course of proceedings. They want people to reach a settlement. Now, we have this little problem because there is an incentive for parties to keep negotiating, which is that as a general rule, the judge won't look at people's negotiations. He'll say, I don't want to see that, because I don't want you showing me an offer from the other side and waving it at me, say, look, he clearly believes that he's liable because he's made this settlement offer. So we have this general rule that settlement negotiations aren't admissible. So you have to, if you are making offers and you want to then rely on them before the judge and say, look, we are definitely a reasonable licensee and we're making these offers, you have to make sure that they don't fall foul of this without prejudice rule. You have to make them as expressly open offers, so that you can then show them to the judge. So that there is that trap that we have, but otherwise, yes, keep negotiating.
And that's maybe another difference, maybe not only in FRAND, but in general between the common and the civil law system. We don't really have this concept without prejudice. So everything that's being said can be presented in the proceedings. It might be bad faith if you're not complying with what you said beforehand, but it's an admissible piece of evidence. That's not the problem.
Mm-hmm. You were explaining before that it's not expected for an implementer to know all the patents that they are infringing, and this is why it's the SEP holder the one who should notify. And now I'm thinking about this notification. I guess it starts with a letter, probably notifying the infringement. What does it have to include?
I guess it would again depend a bit on the circumstances. So as you say, the purpose is first of all to make the other side, to make the implementer aware of the potential infringement. So the minimum requirement is probably to say, who are you? Who are you addressing? Which devices you're talking about? Are you talking about mobile phones? Are you talking about cars? What are the products you're considering? The standards you're talking about? Are you talking about telecommunication standards? Are you talking about video coding? What is actually the standard you're talking about? And then ideally, you would also include either a list of the patents you consider to be infringed, or at least a sample number of patents you consider to be infringed. And in an ideal world, the patentee would even include claim charts where explaining why they think it is infringing, but that's not absolutely necessary.
So in the UK, we have, so we have a general rule in all English litigation is that you have to have explained your claim to the other side. You have to have taken them through it, given them enough information to answer it, and done so in plenty of time before you start litigation. And if you don't, then again, the court can order costs awards against you and penalise you in those respects. Or it can allow more time in the proceedings for the opponent to respond to make up for the fact that you've not given them that information in advance. But there are exceptions when there's good reasons not to tip off the infringer, first of all, if you're the patent owner. One would be, for example, the fear that the infringer is going to rush off to another country and start some sort of declaratory proceedings there. The Italian torpedo was, of course, the classic example that we used to see. So in patent cases, there has developed an idea that you can, in certain circumstances, bring the proceedings when you haven't yet set out the full basis of your claim. So long as you then do so and give the opponent an adequate time to reply. But you have to have some good reason to do that, or you will get penalised in costs at the end of it all.
Mm-hmm. Thanks. Richard, we heard before from Cordula that in an ideal world, we will have also the patent holder showing some claim charts. Could you maybe explain what claim charts are?
Yes, of course. So when a patent has a number of claims at the end of it, classically claim one is the broadest one and the one that's most likely to be infringed, but it's made up of a number of elements. And there may be 10 or 12 elements to the claim. And in a claim chart, you set out each element and you set out why you say this is infringed. So it might be, for example, an aspect of the device that you say is infringed by this particular element. When you're talking about standardized technology, so cellular or H.264 or something like that, what you're commonly doing in a claim chart is setting out each element of the claim, but then you're putting next to it which part of the standard you say is read onto by that part of the claim. so that the implementer can see at a glance, okay, this is why I'm said to infringe this patent. This element is here, this element is here. And it gives him a clear explanation as to what he said falls within the claim. But it also demonstrates that the patent owner has done some sort of check here. He's not just blindly asserting patents. He has a good reason to expect that this patent is infringed by this particular piece of technology. So it's become a standard way of demonstrating infringement of these sorts of patents.
Mm-hmm. Thank you. But here, Cordula, back to you. If I understand it correctly, as you said, claim charts does not seem to be mandatory, but if they are representative claim charts, that could be considered sufficient to fulfill this requirement of notification of infringement. And I wonder, how many claim charts do you need to be considered representative claim charts?
I fear my answers again, it depends. If you have just one patent, obviously you can only provide one claim chart. And if you have like 20, it needs to be a reasonable number. If you have 20, maybe 5 is fine, or even 2 or 3, whatever is representative. If you have 10,000 patents, you're obviously not going to provide 10,000 claim charts. Nobody's going to read that. But it should be a substantial number. And maybe not so much because it is a legal requirement, but I think it has various advantages from the patentee side. First of all, you make sure you are the good guy. You are providing full information or as much information as possible to the implementer. You're putting pressure on the implementer because he's being provided with all that information. He has to react. And also, if you're licensing a larger portfolio and you want a substantial amount of money for that, it's good if you can show that there's some value behind your claims and that that you've thought through, as Richard previously said, that it's you can show that your patents are good ones and are actually being essential. So in that sense, I would always say rather more than less. But of course, it's a question of costs and do you want to advance the negotiations, or do you want to get stuck in technical discussions eventually?
Makes sense. But then, Richard, let's imagine I receive all these representative claim charts, and I am starting to think, I don't think these patents are really essential, or I don't think they are valid. Is it okay if I challenge this validity, this essentiality? And if I do so, can I do it before or during or after the court proceedings?
Yes, absolutely. You can always challenge the validity of the patents. You can always challenge the essentiality of them. Challenging validity, there are mechanisms in all patent offices or around all countries in order to do that. Now, tactically, do you want to? One of the hardest jobs that the patent owner has when he's asserting patents is choosing which ones that he's going to bring against an implementer. And the reason it's hard is because he may have many, many thousands, but he knows that there's a limited number that he can bring before a court within a reasonable time frame. So if I was the implementer, if I was the infringer, I think I would sit back and wait and see which one the patent owner brings against me. And then I would bring my validity challenge in response only against those. There's no point in wasting your effort, wasting your costs on the patents that ultimately don't get asserted against you. So if you target those ones in particular, you've probably got the best chance of knocking them out. And in most countries, you can do so in the same proceedings that they're brought against you. In Germany, it's a little different. You have to start an action either in the Federal Patent Court or if the patents are still in their opposition period in the EPO. But you would challenge in parallel there. And that tactically seems to me to be the better approach for the implementer. Conserve your resources and turn your guns only on the patents that are actually asserted against you.
Makes absolutely sense. And a very good advice, I guess, for those who are trying to use this strategy. I was thinking, Richard, because we mentioned before the automotive, and one of the most debated topic nowadays is regarding who should take a license within the value chain. Automotive is now very present, I guess, in the discussion because they are getting a huge value out of this technology. And I understand you prepare a slide of this because before we go into who should take a license, I think it would be interesting to see how does it work? How is the value chain and who's getting the value out of it and who makes sense to...
Yes, of course. So we have the slide up here. What I mean by a value chain is this: the vehicle has cellular connectivity in it, and it's a product which has an awful lot of components, an awful lot of technologies. But one of those technologies is the cellular connectivity element. And the value chain that goes into the vehicle starts right back at the chip maker, who is someone like Qualcomm or HiSilicon. They manufacture chips, and there's a variety of chips that are necessary to give cellular connectivity, and they don't necessarily make all of them, so they can come from a variety of sources. Those are then put into a thing called a module, which might be made by one of these guys, Sierra Wireless, Gemalto, Telit. And the module combines the various chips onto a card, which is then put into a thing called a telematics control unit, a TCU. And ultimately, it's the TCU that is installed in the vehicle, connected to the batteries, the antennas, the various user interfaces, a thing called a header unit that is the thing that you interact with on the dashboard, and microphones and speakers, and all of that gives the vehicle its cellular connectivity. The problem is that each stage of that chain is generally a different manufacturer, and each stage of that chain, the components are different prices. In a typical smartphone, and in all of the patent cases we've had over the last 20 years, this hasn't arisen because it's pretty well understood in the mobile phone industry that it's the person who makes the mobile phone, this unit, that pays the royalties. And he doesn't seek an indemnity for cellular connectivity for anyone else back up the chain. He pays the royalties. And so it is fairly well understood when you're going to litigate in that area, you sue the manufacturer of the mobile phone. The problem is that with vehicles and with other IoT applications, that convention doesn't exist. And in fact, you have a further difficulty, which is that the vehicle maker, who here I've got him as making 400 to 1,000 euros on his vehicle from adding connectivity in it, he's got an awful lot of buying power over that chain, that supply chain. And the vehicle makers have asked their suppliers to indemnify them for royalties for cellular connectivity. So you have this awkward situation that the vehicle maker is making quite a large sum of money from including cellular connectivity in his vehicle. He's only paying his supplier, his tier one supplier, say 90 euros for a telematics control unit, but is also demanding full indemnity from that tier one supplier. And the tier one supplier is therefore in this incredibly awkward position. They've got to pick up the cost of the royalties for the technology, which I've said here might be 25 euros per TCU. It may be of that order. But they've got this tiny profit margin and they can't absorb it. So that's what's caused so much of the dispute within the automotive industry. The vehicle makers are used to the idea that people in the supply chain deal with the IPR licensing, but the people in the supply chain don't have big enough profit margins to do so. And that has been the source of the dispute. In most of the cases that have settled so far, the vehicle makers have ultimately taken a license, either directly from the patent owners or through a patent pool called Avanci. But it's taken a long time for that to be recognized. This, of course, is just one IoT supply chain. We're going to see exactly the same arguments arising in every other IoT connected device chain. So we can see this problem is going to be repeated.
Mm-hmm. Wow. Cordula, after this, who should take a license? What do you think?
Well, I'm sorry to come back with my standard reply, it depends. I mean, considering this specific scenario, first of all, it should be the patentee deciding where where he wants to give licenses, because it's the patentee who has to make sure that he's giving FRAND licenses, and he has to, if he's always giving it his license at the same level, then of course comparability and non-discriminatory license offers are much easier. And secondly, it is of course in the interest of the patentee to get license fees from someone who can actually pay them. And if you consider that in the end, a license fee is being determined by the value of the technology, and the value of the technology, let's take connectivity here, is really only becoming apparent in the end product, because only when you use and you can use the car and the connectivity, when you can download up-to-date traffic data and things like that, then you become aware of the value of the technology. And that's why the car makers, the OEMs, are actually making this much of money by selling connectivity, like what you say, Richard, between 400 and 1,000 euros per car. While at the tier 1 level, in the end, it's just a chip. There's no real added value, because it's not yet being lived and not yet being practiced. So to make it short, in the end, it should be the patentee deciding. It should be a sensible choice. It would certainly be unfriend if it was erratic and had no business reasons. But I think a lot of points to the end product user, because that's where the money is made, and that's where the money is for a license fee.
Well, I suspect actually it doesn't much matter. The industries will come to agreements within themselves, and I suspect most patent owners wouldn't mind if somebody else in the chain came along and took a license to cover the entire chain. But the point is that if you are one of the other people in the chain, you have to price that into your product. It's no good for the tier 1 guy here to be obliged to take the license, but he hasn't priced that into the price of his product, because then he starts to make a loss. This isn't unique to this industry. If I go and buy a PC from PC World up the road, I can buy a personal computer myself, or if I buy it preloaded with Microsoft Windows, there's a license fee connected with that. The supplier can do that. He can preload Microsoft Windows on it, but he adds it onto the bill. It gets added onto the price for me. So he's arranged the licensing with Microsoft, but I still, as the end user, the buyer, have to pay. So this problem happens all the time, and the reason it's a problem here is the lack of pricing it into the product before it goes down the chain.
Yeah, and as you say, Richard, the buying power. Because if your customer has the buying power to say, no, I'm not paying the top up, then you're stuck, and you have to try to,
you have to say yes,
somehow.
If I'm getting the licenses, then I have to increase the price to cover it.
Interesting. But now, last question. Let's imagine I'm making an offer, receive a counter offer, reject it. Probably we go back and forward several times, and there's a moment of time where the implementer has to deposit. How much should they deposit? What the SCP holder considers as an offer, or what the implementer considers will be FRAND as a counter offer, something in between? What would be your advice?
Well, shall I go first here?
Yeah, you go first. That's fine.
Yeah, it's at least from the German perspective, we do not have settled case law on that. So to be on the safe side, of course, I would say do the maximum amount. But of course, that comes with a cost. What we have seen many times in proceedings is that the implementer makes deposits, or rather gives a bank guarantee on the amount equivalent to his own counter offer on a worldwide basis, because usually a counter offer to be considered FRAND has to be worldwide, with a certain top up. That's what we're seeing a lot in practice, and that could be argued is good enough, because it shows that the implementer is serious with his counter offer, and that he's willing to back it up with a financial security. of course, even though the amounts in place might be very large, actually getting a bank guarantee is not that costly. And you don't have to deposit the money in cash. And that would actually really hurt. But if you're only having to give a bank guarantee, and if you have good credibility with the banks otherwise, that comes rather cheaply. In the end, it hasn't really been decisive lately in the German courts, because even if you deposit the money, if you haven't been willing otherwise, that's not going to save you. So it's usually not the decisive point in the litigation.
And if you are new into the market and you're a small, relatively small implementer, the most important thing here is to avoid getting dragged into litigation, because litigation is it's expensive and disproportionately expensive for most small producers of connected equipment. And I think what I would do if I were an implementer, if I was coming into the market and I was being approached by big patent owners, and they were asking for, let's say, 5 times what I think is my guess is what would be FRAND, I think I would first of all agree some sort of interim payment thing with them. If let's say Cordula is coming after me with her huge patent portfolio, and she wants $1 per device, and I think 20 cents is reasonable, I'll pay her. I'll say, okay, as an interim payment, I'll start paying you 20 cents per device on everything I sell. That does 2 things. First of all, if ultimately I'm wrong and I do have to pay more, then the amount I'm going to have to pay, I've already started paying towards it. So that helps my cash flow position. The second thing is Cordula is far less likely to sue me now, because I'm at least paying her something. And there's likely to be more time where we can have a discussion and work it out. And ultimately, it may be that I can persuade her to start showing me some comparable license agreements, start showing maybe under the cloak of mediation privilege, or maybe through the first steps of an arbitration, so that I can start to see what other people are genuinely paying her. And I can satisfy myself that maybe it's not $1, maybe actually everybody is paying her 60 cents, in which case I will then start paying the catch-up, the 40 cents per device. Yep. And I've avoided being sued. I've avoided spending an awful lot of money on lawyers, and I've got to a much smoother resolution of the dispute. Now, that's a practical thing rather than a what do I have to deposit to avoid an injunction under the Huawei and ZTE rules. But if I were an implementer and I were new to the market, I think that's the approach I would take. And just it's got to be the most efficient way, and it's got to be the way to minimize your ultimate cost, which includes your legal costs of defending.
Yes. And then we will be in this ideal world, right? But then you will not have anything to talk about.
There will always be litigation.
Yes, obviously, wait till we've retired before you adopt that strategy. We need some litigation to keep us going.
Well, thank you so much to both of you for sharing with us your expertise and your experience in this very, very exciting topic. And I will also thank to those who have been joining and are watching this webinar. We would also like to encourage you to subscribe to our newsletter to receive IP news and future events. And you can find the form to subscribe in our website, www.4ipcouncil.com. And well, thank you so much, and hope to see you soon. Thank you. Bye-bye.
Thank you.
Bye-bye.